Reno High School, correct? Okay. I'm Zalal Zogala. I'm a Deputy DA at the Washington County DA's office and a co-coordinator of this program.
And my name is Andy McKay. I'm the Executive Director of the Nevada Franchise Auto Dealers Association and an alum of the We the People program.
Commander Reese, alum of the program, and Carla Baldwin Carrier, United States Magistrate Judge for the District of Nevada.
Hello, we are Reno High's Unit 5. My name is Michaela Schultz.
I'm Kira Johansson.
I'm Ethan Champagne.
I'm Samantha Clements. Our unit coaches Mr. Scott Daniel and teachers Mr. Richard Clark.
Welcome to the afternoon. You deserve to be here. All right. Unit 5. What does the Bill of Rights protect? Question 3. What fundamental American values are embodied in the Fourth Amendment? Why have Fourth Amendment issues been a persistent concern from colonial times until today? How and why does modern technology raise new concerns about the Fourth Amendment? You may begin.
The 1215 Magna Carta asserts, no free man shall be taken or imprisoned of his freehold or liberties, but by lawful judgment of his peers or by law of the land. The Fourth Amendment rests on twin pillars of due process and protection against arbitrary governmental intrusion. We must accommodate new understandings of what is considered private in the age of technology and be secure in the protections that the framers created it for. The Fourth Amendment guarantees people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure, and requires that no warrant shall be issued but upon probable cause.
Privacy has been a persistent concern because its definition has been changed, violated, and redefined. Thus, the search and seizure clause was created. The warrants clause requires the government to adhere to specific procedures upholding citizens' rights. The amendment and the personal rights it secures have a long history. At the very core stands the right of a man to retreat into his own home and there be free from unreasonable government intrusion. The colonists were concerned that fundamental values would be violated by a tyrannical government, as it was when King George III created writs of assistance to search colonist homes at any time and without reason.
This is the same concern of many modern Americans, that the government is listening into and intruding on their private lives. Citizens have decreased their reasonable expectation of privacy with the advancement of technology, allowing for the government to increase their infringement on citizens' intimate private lives. In CAT the United States, it was deemed that the Fourth Amendment is a protection of people, not places. Due process is fair treatment within courts and the right to a fair and speedy trial by jury. In Article 1, Section 9, Clause 2, habeas corpus was protected against even the legislative branch, due to the framers' belief it was such an integral part to the functioning of a free and democratic society.
While these protections are secure in the Constitution, continuously, society has deemed it necessary to expand these protections and accommodate the zones of privacy. Technological advancements in reference to confidentiality create conflict. Constant revision and participation are necessary in the relationship between people and government. In 1961, Matthew, Ohio associated the 14th Amendment and the Bill of Rights as means for protecting privileges and rights that shall not be infringed upon, the 4th and 14th Amendment rights being among them. In this ever-changing Constitution, fundamental rights stand tall among the metamorphosis.
As citizens of the United States reimagine their reasonable expectation of privacy, the Fourth Amendment expands and compensates for society's expectations. From wiretapping in 1928 with Olmstead v. United States to GPS tracking in 2012 with United States v. Jones, technological advancements have made us reimagine the Fourth Amendment.
With the wording of the amendment being left open to interpretation and revision, privacy must continuously be reevaluated. Marcus v. Illinois, Justice Potter Stewart states, technology creates new boundaries and opportunities for invasions of privacy. Technology has redefined society's zones of privacy.
The framers left the Constitution open to promote progress. Zones of one space must be re-examined with the progression of technology. Understanding what is reasonable will promote citizens' expectations of privacy. In The Right to Privacy, Ellen Alderman and Caroline Kennedy state, in many cases, invading privacy is not the only way to ensure our safety. It is just the easiest. By promoting citizens' zones of privacy, the ease of governmental intrusion of the Fourth Amendment will be diminished.
Invasions of privacy and due process are instrumental to the Bill of Rights. The will of the people has always been a protection of their individual rights, and the Fourth Amendment has protected citizens against the oppression from the government, and will remain to strike a balance between the individual citizen and our government. Thank you.
Where exactly is privacy in the Constitution?
In Griswold v. Connecticut, the right to privacy was linked to the Fourth Amendment because it's not directly in the Fourth Amendment. However, in that case, they were talking about marriage, but they did link the right to privacy to the Fourth Amendment.
As well as they link to privacy as the 14th Amendment as well.
Is the idea of reasonable expectation of privacy the only way that Fourth Amendment has been interpreted in terms of protecting citizens' rights?
No, there's also been exceptions with things such as the exclusionary clause, where if a police officer obtains evidence without probable cause, without a warrant, then they cannot use that evidence in court, and therefore protecting the rights of the individual. And while the police officer may have searched it, they still have the right to have that privacy without governmental intrusion of a lawful kind.
The reasonableness test has been deemed a Supreme Court issue, and for that reason, there have been many cases deciding whether or not a person has a reasonable expectation of privacy, especially when looking towards third-party companies or when looking towards technology, especially today. But the reasonableness test is the most prevalent when looking towards issues of privacy today.
Are there lower standards? You guys have been on the fact of search warrants. Are there lower standards in which police can perform stop and search?
Yes, such as with Terry v. Ohio, if a police officer believes that a suspect has a weapon on them or is about to commit a crime, they can stop the suspect and pat them down for weapons to see whether or not they are about to commit a crime.
As well as there are lower standards when looking at searches in schools. The reasonable suspicion standard has been imposed in schools, which means that administrators don't need probable cause, but rather just need reasonable suspicion that a student might be harming the body or the population.
Adding on to my colleague, that this idea of privacy in schools can be seen in TLO v. New Jersey, where this reasonable expectation of privacy, reasonable suspicion was deemed in schools where administrators can pat down students, and their reasonable expectation of privacy is decreased in school.
Should race ever play a role in determining whether to detain or arrest somebody?
It should not play a role just because due process, you're taking someone's life, liberty, or property away from them just because of what they were born. They can't help to cover up their skin. And therefore, through the due process clause, they can't just be arrested due to the color of their skin.
As well as innocent until proven guilty has been decided in Coffin v. United States, as well as in France's Declaration of Rights of Man, as well as within the Universal Declaration of Human Rights. And so deciding something based on race is deciding that someone is guilty based on something that they were predisposed to.
We have this idea of rule of law. Everyone is equal under the law, whether you're Caucasian, African American, Asian, it does not matter. Under the rule of law, everyone is equal.
What about in the immigration context? Say you have a Mexican-looking person at the border and a white person at the border. Should a customs agent use race to determine, among many other factors, whether that person has trespassed or illegally entered this country?
In Moeller v. Minna, it was found that illegal aliens could not be arrested or detained, and that they could still be arrested or detained with a warrant or with probable cause. However, you have to have probable cause, and just because they don't have citizenship here doesn't mean that the Constitution does not apply to them.
You spoke a lot about modern technology in our society now. Do you believe that the Fourth Amendment needs to be amended in order to properly and adequately address the issues that technology pose when we talk about reasonable privacy and things of that nature?
No, because looking at it from a case-by-case basis with the Supreme Court, their rulings on whether or not something is a reasonable search has been sufficient, such as with CAT v. United States and with U.S. v. Jones, where they deemed whether or not something was a reasonable search. And rather than having to go through a whole amendment process with the states, going off of these fundamental rights given by the Supreme Court, we can continue to adjust the Fourth Amendment to our changing environment.
I respectfully disagree with my colleague Ethan. Though he is correct in that fundamental rights have been deemed with the Fourth Amendment and technology, third-party companies have an unexcusable amount of access towards citizens' privacy and private details, and with that, they're allowed to give that out, especially when looking towards banks or even looking at social media platforms, and there isn't enough regulation on how they work and how they detail and decide what privacy is given out towards others.
Is that a private entity as opposed to the government? There's a distinction, is there not?
Terry Gross at NPR stated that corporations have become more like governments with the amount of money they have and with the amount of power they have over democracy and society, so they should be treated just like a government official, in my opinion.
In your opinion, should a private email server be protected completely under the Fourth Amendment?
You would need, I believe that you would need probable cause and to have the same standard within the Fourth Amendment that we have currently with the warrants clause. However, this has become a problem because of the Smith and Miller decisions in which the third-party doctrine said that you willingly sign away your right to privacy.
But in today's society, you have people that are willing to put basically their location, what they're eating, where they're going to movies or what have you. Haven't they really given up much of their privacy rights by signing up for things like social media?
While our reasonable expectation of privacy of our personal lives has been decreased, what we consider to be sorry, may I?
Yeah, please continue
Thank
your
you.
thought.
While we have given up some of our personal information towards social media, what we consider to be private inside our homes, inside our phones, our location, our text messages, our calls, all of it must still be protected under the Fourth Amendment and a need for probable cause and a need for a warrant.
Thank you. Okay, there's amazing. Very amazing. I'm gonna be a little bit more difficult with you than I've been in the past, mainly because I have a very big, strong feeling that you are going to be moving on at some point in this competition. There was a question about email servers, Stored Communications Act, 18 USC section 2703B will give you the answer to that question, okay? When we talk about the reasonableness of privacy versus any other standard, Jones. That's actually a question about whether or not attaching a device physically to somebody's property violates the Fourth Amendment. So you have the reasonable expectation of privacy analysis. On the flip side, you have the property analysis. So if you get that question, there is other ways of looking at Fourth Amendment violations than just through that lens of reasonable expectation of privacy. You guys, I could go on, but I'm not going to because you guys did so great, and I don't want you to think that you didn't. You did amazing. Congratulations on getting this far. You have a lot to be proud of.
Thank you.
I echo exactly what she said. Again, I will probably be a little bit harsher this time and not be able to gush as much. Very pleasant watching you guys all over again. Again, blew it out of the water. I asked, where do we see privacy in our Constitution? And what I'm really looking for is someone to hit on the privacy number, right? All of us, privacy number. That was really what I was just looking for, but you made up for it and strived with all of the other answers, all of the other evidence. I really don't know how to help you. Really stellar job. And you guys, this time around, especially, you all contributed to answers, and thank you for that, because that's something I think we mentioned last time, and that was probably did very well this time.
Thank you.
I obviously wasn't here in the morning, but I will say this, that I did to both Incline and Reno, or Reed, this is Reno, thank you.
Don't get those mixed
The
up.
three, Reed, Reno, and Incline, right, wrong, or indifferent, but the reality is this. You guys are held to a higher bar than everybody else. And in order for you guys to compete, you have to jump over that bar. It's a hell of a lot harder for you guys to do it than the other schools, and it's no disrespect to them, it's just, you guys have been doing this a while, you guys got veteran teachers and coaches, and you jumped over the bar. I'll say that, with a lot of room to spare. I was going to hit on the issue with respect to privacy, and the simple answer is it's not there. And then explain why. But it really, you guys are great, I can tell you that all day long, but the fact of the matter is that's actually a really simple question. Nowhere in the Constitution does it say it. Now, obviously, it's implied in a million different, citations, you know, via case law and, findings in the Supreme Court, District Court, on and on and on, but, I think you guys are probably gonna be 9-1. Just a hunch. If your other units are as good as this, the one thing that I will say that really impressed me was the complete balance with the four of you guys. That's hard. That's really, really hard, and you guys did it. None of the material. Enjoyed it, and I appreciate you letting us listen.
Thank you.
So I first met you on Wednesday, you remember? And I said, I'd never seen a team with such distinct personalities that operates as one unit. And you were practicing on Wednesday, and I didn't think you could get very much, I didn't think you could get much better. Because you guys were really good on Wednesday, and you did get better. I don't know how that happened. I'll get better. The depth of knowledge and the resourcefulness is mind-boggling. I was, you know, Matt versus Ohio, Olmsted, Jones, Terry, Katz, right? Jones again, Griswold, right? And we don't hear Terry all the time. We should, but we haven't in all the schools. And Terry is obviously applicable here. Terry Gross, I've never heard her cited as a source for constitutional law. And let me just tell you, I'm going to be a bit critical because you guys need this. She's not a constitutional scholar. She works for NPR and she's a fantastic journalist. But private corporations, no matter how many public functions they do, right, do not have, the Fourth Amendment does not apply to them. They're not going to. So say that point, that's fine, but start it by saying state action is required for the Fourth Amendment to apply. However, and then you can say your point, okay? And then on my question in terms of race, I don't know if somebody's going to ask you this in future competitions, but they might. United States versus Brignone Ponce, your teachers know this, right? That's a case that says race can be considered in a limited circumstance in the immigration context, okay, to determine if you can pull somebody over. It's not the only factor, it's just one of many, but know that, okay, because you don't want to say race can play a factor because you don't want to sound like a jerk, right? But it's true, it can, and if you answer that question in future rounds, I think you're going to blow the judge's socks off. So, good job.
We already did.
Yeah.